Hi, everyone, and welcome to our webinar, The Rule of Law, the Foundation for Justice and Stability for the Energy Industry. I am Ryan Frompazulli, Staff Assistant for the Institute for Energy Law, which is an institute of the Center for American and International Law. I will now pass it to T.L. Covage, President of the Center for American and International Law, who will introduce the topic as well as our moderator today.
Thank you, Ryan. As President of the Center for American and International Law, I'm the successor to Robert Story, founder and first president of what began in 1947 as the Southwestern Legal Foundation. The Institute for Energy Law is one of the oldest and best established components of the center, but it has a multifaceted set of operations, all devoted ultimately to the administration of justice and promotion of the rule of law. We have a proud history, and energy lawyers have been a vital part of it through 75 years of the center's development and growth. As we celebrate the center's 75th year, it's very fitting that this group of energy lawyers are here to discuss the role that this aspect of the center has played in promoting the rule of law and thus CALE's essential mission. I thank all of you for being part of this event today. I'd like to introduce the moderator for today's discussion. Larry Simone is Senior Counsel at Lisco & Lewis in its Lafayette office and a very seasoned energy professional who's served clients throughout the country and affected operations really around the world. And I'm proud to say that in a prior part of my career as in-house counsel, I've been a client to Larry and his team. And I know that the high quality of work that they and others on this call have provided to their clients and in their own way done to promote the administration of justice and the rule of law. Larry, thank you for being our moderator and for being part of this program today. And I turn it over to you.
TL, thank you for the opportunity to work with you and to work with the center. Hello to everyone in the audience and welcome to the webinar on the rule of law presented by the Institute for Energy Law, honoring the 75th anniversary of the Center for American and International Law. The rule of law has been fundamental to the mission of CALE, but it is also fundamental to our concept and experience of liberty and of justice and of the protection of property and contract rights, and really of commercial stability in the energy industry. We have an extraordinarily gifted and experienced and scholarly panel of speakers for you today who will discuss with us the virtues of the rule of law, its strengths, and its values for us in preserving it. Let me introduce them to tell you that they are Professor Nadia Netzel, Mr. John Bowman, Judge Eduardo Prado, and Jack Balasia. They will have a conversation with us about the meaning, the function, and the significance of the rule of law and its effects on our daily lives, but as well on the commercial activities, on the energy industry, and on our life in general. These four people have devoted much of their professional lives to the preservation and enhancement of the rule of law and relied on its presence and application in their activities as a foundation for freedom and justice in society and in their commercial affairs. Their extensive experience and varied backgrounds are a true testament to the profundity and complexity of this historical phenomenon that we call the rule of law. Three are, in fact, university-level professors. I refer you to their individual biographies, as was offered by Ryan, for details on their careers, but allow me to say just a few words about each as an introduction for this program. Professor Nadia Netzel will speak first. She is a true scholar of the rule of law. She's a professor emeritus, retired at Southern University. She's written several articles on the rule of law and a couple of books on the rule of law. She will address us with regard to the definition of the rule of law, its differences and commonality in meaning under different legal tradition. She continues her scholarly research and teaching, even though she's retired as a professor. We look forward to her remarks. The next speaker will be John Bowman, an internationally known arbitrator, advocate, and expert on energy contracts. He was honored by the Institute for Energy Law as a Lifetime Achievement Award in Energy Litigation. and he teaches at Georgetown Law School. He is an expert and an arbitrator, and we're pleased to work with him on this. The third speaker will be Judge Eduardo Prado. Now, I could say Mr. Ambassador, but he prefers to be called Judge. He was a former U.S. attorney for the Western District of Texas, a public defender, and spent 35 years on the federal judiciary and the District Court and the Fifth Circuit Court of Appeals. And then he was the U.S. Ambassador to Argentina. He now works with the law firm of Bracewell. He has seen the rule of law function and fail from multiple perspectives, and we will benefit from his rich insights. The final speaker will be Jack Malaysia. Jack was a renowned trial lawyer who was brought in-house by ExxonMobil and ultimately became general counsel of ExxonMobil. He's now retired from that company. But like John Bowman, he was honored with a Lifetime Achievement Award in energy litigation, and he now teaches at the UT Law School. The work of Professor Netzel deserves your attention, and I'm sure she will leave us with some citations to her work. So we turn first to her for her thoughts on the origin, the meaning, and the impact of the rule of law, or its absence in its historical evolution. Professor Netzel.
Oh, thank you, Larry, for that beautiful introduction. I hope I live up to it. I have a very short PowerPoint presentation that I'm going to share with you, I hope. Let's see if I can bring it up. There we go. This view is a little odd, but that's me. And on the right side of your screen, you'll see my latest book, The Rule of Law, Economic Development and Corporate Governance. How did corporate governance get in there? Well, I've been doing this work for a long time, but corporate governance is sort of a hot topic. So when I looked for a publisher, they said, oh, it's got corporate governance in it. Well, we'll be happy to use it. But in addition to teaching law, I did practice for a bit in international trade and admiralty, did a little work with some clients that were in the oil business. I clerked first for Carl Stewart. I worked as a staff attorney. And this is my favorite was being a law professor. Was my goal, and I was late to the table. But in any case, let's get started with the definition of the rule of law. There are actually three possible relationships among law, government, and people. The first one, I don't think anybody wants. That's no law and no order. It's chaos, anarchy, and there's always some place in the world that you experience that or see that. Then there's order, but no law. For example, Putin says he has the rule of law, but then there's Yukos, where he declared a company had not paid the taxes that that were applied retroactively, and then declared it bankrupt. So we don't really want that either. So what is it when we talk about the rule of law? Well, there's a certain universality to it, thanks to something called the World Justice Project, which I'll talk about in a minute. But I think the simplest definition is the one that Hayek developed. It's law and order plus limited government. Government in its actions is limited by itself, by the institutions that have been set up. I think the favorite American expression is the rule of law and not of man. So the World Justice Project, which is I'm starting my timer a minute late. World Justice Project is a non-governmental organization that collects data on the world, on the rule of law around the world. 140 countries participate in this. The current CEO is William Hubbard. He's also the dean at South Carolina, which is where I am. I had a privilege of speaking with him a couple of weeks ago. And their first principles, their four basic principles of the rule of law is that first, government must be accountable and its power limited. As I said, limited government, Hayek. The next one, the law must be clear, publicized, stable, and applied evenly, including human rights, property, contract, and procedure. Now, this list of attributes of law, I think, is developed from Lon Fuller's famous book, The Morality of Law. And indeed, I've seen the World Justice Project sort of morph its definition of the rule of law over time. And but Lon Fuller's has always been part of it. They are now emphasizing limited government, which I think is key. Government must be open. The processes by which laws are adopted, administered, and enforced must be accessible, fair, and efficient. The efficient becomes an issue when there's too much law, too much of an administrative state. Hernando de Soto, the Peruvian economist, spoke about this, but others have as well. Hayek, Leone, even DC back in the time. And the fourth is that justice must be accessible and impartial. And I've seen wonderful changes towards this in Chile, which redid its entire criminal justice system about 20 years ago through consensus and bottom-up morphing. I'm hoping that with technology that justice will become more accessible around the world. This is an interesting slide. I'm comparing data here from 3 different non-governmental organizations: the World Justice Forum, the Fraser Institute, and Transparency International. And I need to emphasize that the rule of law means something slightly different in civil law than it does in common law. The World Justice Forum has reached sort of an amalgamation of the two, or a compromise, if you will. But there are still very much cultural and traditional differences between the two concepts. The civil law world outnumbers us by about 9 to 1. Common law jurisdictions account for only 10% of the world's jurisdictions. If you define common law jurisdictions as those that incorporate judge-made law fully. What you'll notice here is that in each of these 3 dynamics, common law outperforms its small percentage. So when we're talking about the rule of law, 8 of the top 30 countries, this number is from 2019, it's now 8 of the top 27 countries, so 30% are common law. I'm talking about jurisdictions as well, so that includes Hong Kong. When we go to, so you look for the green here, economic freedom of the world, you look for the blue. Hey, it's the same suspects that are in the blue field, and that's 8 of the top 15 countries. Again, in 2019, 53%. That number has gone down a little bit since I made this slide. Transparency International, gold, go for the gold. Same suspects, the same 8 countries are at the top, between 27 and 33%. So my studies tend to focus on why is this? What is it about the Anglo-American heritage and the civil law heritage? And I'm a trained civil law attorney. I'm a Louisiana trained at Loyola in civil law. So what is it about this way of approaching law, government, and man that is a little stronger? I mean, that's the focus of my research. So how did they develop? I think the best explanation for anything is a historical one. So they develop out of from the 12th century, from customs and traditions in both common law and civil law. And I promised Larry I would not start talking about things like Descartes and Cartesian stuff, because your eyes will cross. But I could go into that for hours. The civil law, I would call it Rechtsstaat. It's rule through law, or l'état de droit. Same thing, rule through law instead of rule of law. It's slightly different, but the World Justice Project has actually made a very good amalgamation of them. Scholarly theories, however, about law, I think do not necessarily reflect practice, and I think sometimes they're even dangerous. Some of the ideas coming out of law schools today, and yeah, I'm one of them, but the critical legal studies movement concerns me a great deal. I don't think it has positive outcomes. the way the traditional practical way of looking at the rule of law. What practical by meaning, what is the practice? Where do we see it in real life and in practice? I think that's a better way of looking at it than trying to come up with some theory about it. But in sum, the rule of law is necessary. Limited government, law and order, respect for law and order, mutual respect, comity, and I think especially what Lon Fuller emphasized, which is reciprocity. Do unto others as you would have them do unto you. So contract is really something that developed out of the concept of reciprocity. And so I think that will lead probably pretty well into John Bowman's talk, but I thank you for the time. Spasiba, merci, gracias, and sheshe. And thank you very much for the time. I'll stop sharing and I will mute.
Thank you, Nadia. We'll turn now to, as she said, to John Bowman. John, for your observations and your experience on how these philosophical bases became the rule of law, or actually played out and developed and evolved over time, as you saw it, as a basis for protecting property rights and contractual sanctity in the international energy business. You have a unique background in that, and we'd look to you to follow up and explain that to us.
Thank you, Larry. And thank you, Nadia, especially. My perspective, my understanding of the rule of law comes from my career in international energy disputes. And so the perspective that I have is really looking at the rule of law through the prism of international energy development, contracts, and disputes. And for me, I think to understand the rule of law in this context, we have to look at the cyclical clash, what I would call the cyclical clash, the periodic, the repetitive clash of permanent sovereignty over natural resources and the sanctity of contracts. And so in this context, what do we mean by the rule of law? Do we mean permanent sovereignty over natural resources, which is part of customary international law and is reflected, I think, in almost all of the constitutions of resource exporting countries? Or do we look at the notion of rule of law in the context of party autonomy and the juridical respect for party autonomy, that a sovereign has the power to bind itself irrevocably with a foreign investor with respect to natural resource development? So the question can boil down to sometimes simply, or more complex, with more complexity, depending on how you look at it. Does the rule of law stand for sovereignty, or does it stand for sanctity? And obviously, I'm not the first person to use those words and to think and to think those thoughts. And does the rule of law, has it changed over time, over the decades in which international resources have been explored and developed and exported? And I think it has, from the post-World War II decolonization period to today. I think there is a way to see an evolution in this context of the rule of law. And there's certainly two cycles that drive the rule of law. One, the commodity price cycles, and the other, on a less macro scale, the project life cycle. Both of those cycles drive the importance, the focus on, and the contentious resolution of disputes based on the rule of law. And last, in terms of a point I will make as an introduction, we've seen in the last 2 or 3 decades, probably just the last 2 decades, one could say since the downfall of the Soviet Union and the work that was done to establish, however short-lived, the rule of law in Russia with respect to production sharing contracts, a very sophisticated system of risk mitigation developed and used in and as part of resource contracts. And so one question I have is, can we think today of the rule of law as a rule of contracts? And I'll explain and give you my thoughts on that in just a minute. 60 years ago, this debate was framed, I think, in a rather dramatic way by a man named Frank Hendricks, American, who advised Saudi Arabia, and by George W. Ray Jr., who was at that time general counsel of Aramco, at that time an American company owned by the companies we now know as ExxonMobil and Chevron Texaco. And they had a debate. In effect, Hendricks arguing that changing circumstances and the sovereign's power to change itself unilaterally, to change its agreements unilaterally and alter them at its will, was the right of the sovereign state. And 1 year later, after Hendricks had presented that position, Ray responded at an event of this association, of this foundation, the Southwestern Legal Foundation, and took a different view, emphasizing two principles: the contract as the law of the parties, and pacta sunt servanda, the contract shall be obeyed. For the next 14 years after that time, and this was 1959 that Hendricks spoke, and the next year, 1960, when Ray responded directly to Hendricks's claims regarding the sovereign's unilateral powers. And within the next 14 years, during that time, the same debate went on at the United Nations General Assembly and was reflected in various resolutions, very famous resolutions, adopted on the subject of permanent sovereignty over natural resources. Now, there's no question that price cycles drive many of these battles over the rule of law and over the sovereign's right to unilaterally change its position. It's to unilaterally, in fact, change the terms of the parties' contracts. Thomas Walde, whom many of you would know, said it perfectly, I think, in his article from 2008, which aptly was titled "Renegotiating Acquired Rights in the Oil and Gas Industries. Industry and Political Cycles Meet the Rule of Law," when Thomas recognized that it's at the time of high oil prices frequently that the leverage between the investors and the government shifts. And in those situations, frequently the government takes an aggressive position with respect to its rights of permanent sovereignty over natural resources. And then there's also the obsolescing bargain, the shifting of leverage within a project life cycle that similarly often triggers with the shift of leverage and the shift of power within that relationship to result in disputes and result into conflict over the rule of law. I was just contacted a week or two ago, and these same issues that we saw arise in the 1950s are still alive and well in the world with respect to changing circumstances and the application of the rule of law. I want to point out two modern day lessons or tell you or offer, suggest to you two modern day lessons regarding permanent sovereignty over natural resources and the rule of law. First, as I said a minute ago, over the last 2 decades, there's been a dramatic increase in the sophistication of risk mitigation provisions and systems within production sharing contracts and other forms of host government contracts. And as an example, here's my one demonstrative exhibit today. This is the famous 2016 ESSO E&P Guyana contract. And I raise it up here because each of the yellow tabs that you'll see is a stabilization provision. There are 13 stabilization provisions in the ESO contract, along with very sophisticated application of law and dispute resolution and waiver of sovereign immunities. So what we see not only in this contract, and admittedly, this was a frontier play, and it was with ExxonMobil, and they offered the management skills and the technology and the deep water experience and the capital budget that was very attractive to Guyana. Not everybody can fill their shoes, but nevertheless, we see this around the world, more reliance today whenever the leverage is available to the foreign investor to adopt very sophisticated risk mitigation provisions in the contract. Some, in fact, here in the Guyana contract, those provisions take two main types. They're either exemptions from fiscal obligations, fiscal burdens, or they're allocation of fiscal risk from the foreign investor to the host government even, or to the national oil company. And then the second modern day development, which I think disappointed a lot of people, but it's something that needs to be recognized. The Hardy exploration and production dispute with India from a few years ago, Hardy being a US company, Hardy entered into a PSC with India. India terminated the PSC, clearly expropriated the contract without a legal basis. And I can say that because it went to arbitration. 3 former Indian Supreme Court justices unanimously ruled in favor of Hardy in that arbitration and issued an award declaring that the government must return reinstitute the PSC and also return the contract area to Hardy. That then came to the United States, to the DC District Court, and the DC Circuit balanced permanent sovereignty over natural resources and the need of the US courts to respect another government's sovereignty on the one hand, and the policy in favor of enforcing foreign arbitral awards, of course, under the New York Convention and the Federal Arbitration Act. And the district court ruled that the forced interference with India's complete control over its territory violates or would violate the public policy of the United States. And therefore, the district court refused to enforce that award, at least the declaratory judgment portion of that award that would have required India, assuming it could be enforced. And so this shows one area of explicit articulation by the federal courts here that in some situations, permanent sovereignty over natural resources will trump, in my view, will trump the rule of law, because the rule of law was clearly utilized and applied by the 3 Indian Supreme Court justices unanimously in favor of the other party. So where does that leave us? It leaves us with a recognition of the importance of modern stabilization provisions in these contracts as, I think, tools of the rule of law. And it leaves us, if I may, with another article, another presentation by George W. Ray Jr., the Aramco General Counsel. In his article from 1961, Some Reasons for the Binding Force of Development Contracts Between States and Foreign Nationals, and just let me read this to you. And he's talking about 2 enduring principles, in his view, that enables economic development, facilitates worldwide economic development and progress. And he wrote, "It is apparent that the ad hoc law of contract, meaning contract as the law between the parties, and pacta sunt servanda, contracts shall be honored, came into being initially and have endured throughout the centuries for sound reasons. During these times when the absolutists," and here he's talking really about the Soviet Union and communism at that time, this is 1961, "during these times when the absolutists are endeavoring to establish state dictation, as mankind's only rule of life, meaning rule by law or of man, development agreements, economic development agreements, and these enduring principles which have withstood the ravages of attack and time, furnish ample reason for us to believe that good faith performance of contractual obligations will find support now and hereafter under a worldwide rule of law. And I wanted to share that with you because of the words itself, the concept itself, and also because within a few years of writing that, Mr. Ray became chairman of the advisory board of the International and Comparative Law Center at the Southwestern Legal Foundation in Dallas, Texas. And so proving Larry's point earlier and Tom's, that the foundation has had an important and central role from the very beginning, both in enforcing and championing the rule of law, and especially with respect to energy resources. Thank you.
Thank you, John. That's not only a scholarly, but a fascinating statement of the development or evolution of the contract theory as it evolved over time. If we skip now to Judge Prado, would ask Prado to pick up on those concepts, but drawing on his experiences as a U.S. attorney and a federal judge, and reflecting on the significance and meaning of the rule of law in those experiences and those roles, and then look at Argentina as a comparison, particularly how the rule of law or its failure impacted the energy industry, and especially in light of John's remarks about sovereignty, how that played a role in Argentina in terms of the control of resources and the ability of contract to be followed or observed. So, Judge, if you would, I would look forward to your remarks. Thank you.
Thank you. I thought I'd share with you some of my experiences in my different hats career as a prosecutor, defender, judge, and leading up to my last experience in Argentina. I think the first time I questioned what exactly is the rule of law was when I was a young public defender, and I was appointed to represent an 84-year-old woman, widow, in a wheelchair on welfare, who was charged with cashing her husband's welfare checks for over a year. Chose to go to trial. It was obvious she was guilty. She'd been cashing her husband's welfare checks, and he'd been gone for over a year. But I took a shot, and the jury found her not guilty. And I did not argue jury nullification, but I questioned, what is the rule of law? The law probably should have found her guilty. It was obvious. The facts were there. She committed a crime, violated this law, but 12 citizens found her not guilty. And I think it was because she was an 84-year-old woman in a wheelchair on welfare and felt sorry for her. And in this particular situation, the jury just ignored the facts. It was in my favor, but I questioned whether it was the correct ruling, even though I'd won. And that was the first time I really thought about, what does the rule of law mean? Do 12 citizens have the right to review the laws passed by Congress and make a final determination? And I questioned it then. Now, my different hat as U.S. attorney, a U.S. attorney has the discretion to not enforce all criminal violations. A prime example today, and it was back then, is all the immigration violations that are taking place. Hundreds of people are crossing the border, and technically, they are in violation of laws passed by Congress. But it's been decided that the courts cannot handle numerous prosecutions of so many people. So a majority of them are not prosecuted. And so we're not enforcing the laws passed by Congress. So is that correct? As a practical matter, the Justice Department and U.S. attorneys don't have the resources to do that, and they're minor offenses. But still, it's an example of the administration or U.S. attorneys, and not just this administration, because it goes back to when I was there 30, 40 years ago, are not enforcing the laws equally and deciding who gets prosecuted and who doesn't. So I questioned it back then when I was U.S. attorney. I put my head on as a judge. And what is the rule of law? I had several cases, several circumstances where I saw something that was unjust, unfair, but the law did not give a remedy to that victim, I would say. And so my hands were tied, and I ruled that the person would not be successful in their litigation because the law did not give them a remedy, even though it seemed like it was unfair and unjust. And so a judge is supposed to follow the law, not make up their own law. And that gets me to the appellate court, where we have strong arguments over what is the meaning of a law. And some judges like to broaden the meaning of the law, and others like to restrict the meaning of the law. And what is the rule of law? Where do we draw the line? And that's where we get, I think, some of the biggest arguments in the appellate court, interpreting laws and enforcing laws and deciding what is the rule of law passed by man. And a lot of times it's not clear as to what is the law. And we have some of our biggest disputes on the appellate court. Now I turn to Argentina after 30, 40 years of working within the US legal system and thinking pretty much the rule of law, even though I have these questions as to how you apply it in our courts. Now I'm going to a foreign country and expecting it to be very similar. And I found out that the rule of law means different things depending on the circumstances of your particular government and your particular country. Most countries, a lot of countries say they follow the rule of law, as you've heard, but they have a different interpretation to that meaning. Argentina, where I was at, is going to have 100% inflation this year. We complain about our inflation, but Argentina is going to be 100% inflation. People from one week to the next really do feel the cost of merchandise going up. They're on the verge of going bankrupt for the 9th time. When I got there, they owed almost $300 billion to the rest of the world. They're in heavy debt. They have a progressive government that's left-leaning, that wants to have import substitution and prefers local merchandise to foreign merchandise. They want to achieve industrial self-sufficiency. And so foreign countries are in some ways discouraged by local law to come to Argentina. Yet there's a lot of potential there, and there are over 300 US companies doing business in Argentina. And as ambassador, it was my responsibility to represent those countries before the Argentine government. And a lot of those companies had contracts with the Argentine government. But given its politics, given its economic situation, they were very flexible on how they interpreted the law, to the frustration of US companies who are used to the law and the contract being the agreement, and would be frustrated, as I was, because I wasn't used to something like that, and asked me to go talk to Argentine representatives and convince them that they were bound by a contract. A funny situation that happened was the Belgium ambassador approached me Belgium had for over 25 years had the dredging of the major river in Argentina that borders Uruguay and Paraguay. It's part of Brazil. And a lot of their major products come down this river. Well, China comes along, and China doesn't play by the same rules that everybody else does. China interpretation of ethics and the rule of law is way different. And they're very aggressive about approaching things. So they approached the Argentine government and said, we can dredge your river for a lot less than the Belgium company comes. So why don't you just, let's have a new contract. So in the middle of the contract with Belgium, China is trying to get the Argentine government to avoid that contract. And Belgium came to me to ask me as US ambassador that they were concerned, that I should be concerned because China was going to take over control of the major river between these countries. So in an indirect way, I was very interested, but that was an example of the type of things that the Argentine company, given its desperate situation, would look at. Some of you that were involved in energy know that Argentina has great deposits of shale oil, and they could, had they developed it, be self-sufficient in oil and gas. But because of politics and other issues, they have not developed their oil and gas. All the US companies are down there, Exxon, Chevron, everybody's down there, but you get into frustrating situations where, depending on the government, there can be some favorable statutes or there can be some unfavorable regulations, depending on the economic situation. I saw the difference just overnight between our change of administrations, where the previous administration was more supportive of oil and gas, I guess, and not concerned with renewable energy as much, and global warming. The new administration came and voiced its concern with global warming, and it influenced the Argentine government to now look at renewable energy as a source of energy and not emphasize as much its oil and gas industry. And so they're between a rock and a hard place on how to handle the oil and gas industry. They put a lot of pressure on US companies to manufacture all their products needed for developing oil and gas in Argentina, but it was much more convenient for US companies to manufacture it in Louisiana or Houston and ship it down there and put it together. But they'd get all sorts of pressure to set up factories in Argentina and manufacture all the oil rigs down there. Interestingly, on how they see oil, the rule of law, they're much more political. The judges are under a great deal of influence by the executive branch and the legislative branch. They run a lot of things by executive order by the president without the legislature approving it or the courts getting involved. The president files executive orders that override contracts sometimes. And an example of how they viewed the rule of law or how it's interpreted as a federal judge, I knew I can't get involved in influencing judges, but I got a call from their Secretary of State because some years before, as you know, YPF, the oil company there was nationalized, and 50% of it was taken away from a private Spanish company that owned the oil company. It resulted in a very large $10 billion lawsuit that I think is still pending up in New York over that, where Argentina just took over half the oil company belonging to a company in Spain. The Secretary of State from Argentina calls me and says, Mr. Ambassador, I know you were a judge for many years in the United States. Do you happen to know the judge in charge of this lawsuit in New York? And I said, yes, I know her. And he says, well, I sure would you appreciate a call from you to her, emphasizing how important it is for Argentina, because we can't afford to lose this lawsuit. And maybe if she would let the lawsuit come back to Argentina, we could handle it down here, since it's a lawsuit involving our oil company down here. Well, the contract clause did provide that the lawsuit could be filed in New York, but I had to tell the Secretary of State of Argentina that it was inappropriate for me to be involved and call judges directly and try to influence them. But in Argentina, it seemed to be the routine that the executive branch could call a judge and pick up the phone and call him. But many of the US companies were frustrated because the legal system there is not perceived as being fair. The public doesn't have faith in the legal system. And many times the cases would get bogged down and the judge would not want to make a decision, and US companies would get frustrated because lawsuits would pen for 5-10 years without a ruling. And US companies would come to me and say, we need a ruling. We need to figure out what our future is going to be like in Argentina. And we can't go on this way. So we don't care what the ruling is anymore, so long as there's a ruling so we can make our decision as to what we're going to do in the future. This has caused companies to be discouraged from doing business in Argentina. If you can't have faith in the legal system of the country and contracts are being voided by the courts and the local government, what guarantee is there that you can do business there and feel that you're being equally and adequately represented in the local government there? So it is a concern because Argentina needs to have foreign investment, yet because of its legal system, there are many companies that think twice about investing in Argentina. So I found this very interesting as to what the rule of law is in Argentina compared to what the rule of law is here in the United States. The one story that I share with people is not in Argentina, but in Bolivia. Evo Morales had been president for 3 terms, and under their constitution, the constitution passed in Bolivia, there was a term limit like here. And the president had finished his 3rd term, so he filed suit before the Supreme Court. Very conveniently, everyone on the Supreme Court was appointed by him, claiming that his human rights were violated by the Constitution because the Constitution limited him to 3 terms as president. The Supreme Court unanimously ruled that the Constitution was unconstitutional because it violated his human rights to run for a 4th term. And sure enough, he was able to run for a 4th term. But it's just like, how can you rule that the Constitution is unconstitutional or illegal because it violates your human rights? But one of the frustrations I think the US companies have too is how aggressive China is in South America and in Argentina. And as I said earlier, they don't play by the same rules. And it's frustrating for US companies who have certain rules and regulations and laws that they must abide by, and yet they're competing with someone who doesn't play by the same rules, who is unethical in many ways, bribes, fraud. There's no limit to what China does, and it makes it very difficult and frustrating. Lithium is a big product in Argentina right now that we want to develop, the US wants to develop, but China is coming in very aggressively with local governments and buying up all the lithium and the lithium mines and resources. And it's very difficult for us to compete with them. So maybe I've rambled a little bit, but this is my experience with the rule of law, starting as a young public defender and interpreting some of these rules that we have in the US and how they fit in with the rule of law compared to a foreign country where they claim they follow the rule of law, but it's very flexible depending on their politics and their economic situation. So I hope that's given you a little bit of an idea of my experience with the rule of law and exactly what it means or does not mean.
Yeah, Judge, thank you. That's a stark contrast between what the expectations of companies are when they go down there and what they actually experience. I appreciate that. And picking up on that, Jack Malaysia is next. Jack, you've seen a number of instances, I know, of stark contrast from almost every angle, given your background and experience. So given that, what are some of your conclusions and observations from this wealth of experience regarding the application and experience of the rule of law?
Thank you, Larry, and thanks to the rest of the panel for their presentations. My perspective is, as you suggest, I've been sort of a participant in this concern about the rule of law. You know, oil and gas is often found in places that are remote, where the rule of law is either non-existent or relatively new. And the fact of the matter is, oil companies are not going to invest in these new developing countries without some assurance that these investments are going to be protected, because as everyone knows, these investments are huge, billions and billions of dollars. They take many, many years to reach fruition, where the company is actually getting a return on its significant investment. John mentioned Guyana. That's a great recent example of discovering reserves in a developing country. And as he pointed out, the provisions of that contract contains many provisions to try to protect the investment that the companies are making down there. And there are plenty of examples of places where it's been difficult to do business because the rule of law is not either not strong or not developed. Venezuela has now expropriated nationalized oil companies twice. And one of the amazing things is, after they did it the first time, that sometime later the companies decided to go back and try again, which just tells you how important access to these resources are. So I think the bottom line is that without the rule of law, either contractual or embedded in some kind of investment treaties, bilateral investment treaties, or some ability to protect the huge investments that are being made, those investments will not be made. And I think there are examples of that as well. You know, when Mexico first opened up its resources 5 or 10 years ago, when they did their initial bids, there were very few bids that were submitted, because one of the provisions that the Mexican government was going to require was that any disputes be resolved in Mexican courts, and that was a real problem that they ultimately had to get around. So, and I may be stating the obvious, but dispute resolution and arbitration clauses and investment treaties are really what make these investments by energy companies possible. And absent some rule of law, those investments are not going to be made. Now, let me also suggest, and I'll tread lightly on this, that the rule of law issues are not just a problem in foreign countries. I'm going to suggest that there maybe are places in the United States where I think one of the tests or tenets of a rule of law is that the law be applied evenly. And I think without naming any names, I think there are places in this country where one could argue that the playing field is not level and that law is not being applied evenly. Finally, let me stress the importance of having organizations like CALE that advocate for the rule of law. You know, when as TL mentioned earlier, when Dean Story started the Southwestern Legal Foundation many years ago, his purpose was to educate lawyers all over the world to improve the quality of justice and to extend the rule of law wherever it could reach. And CALE, I think, has accomplished much of what Dean Story intended. It has served tens of thousands of lawyers and law enforcement officials all over the world, from all 50 states, 130 countries, and it continues to advocate for the rule of law. And there are many other organizations that do that. And if we're going to continue to hope that the rule of law gets embedded in more and more places in the world, we have to have organizations that are willing to advocate for it. And one of the good things about CALE is that it does that. So thank you, Larry. That's all I have to offer today.
Yeah, thank you so much. You know, the contrast that we see throughout this discussion creates a perception for me that the rule of law is precious, that it needs to be strengthened, even in our country. As you say, you know, you're going to court when the playing field was not even, and we need the rule of law in this country and throughout the world. I mean, the ABA for what 30 or 40 years had a great program going in Eastern Europe, those kind of things. And the role of CALE has been so important. But in any event, I know we're at the end of our time. I want to thank each of the panelists for your hard work, for your observations. I know that Nadia had an observation about where Argentina fit with the in the World Forum Index. And it was down, I think, in the low 50s or high 50s, excuse me, compared to other countries. So and fallen. So that, you know, the observers bring these observations to us. We can join with CALE in trying to advocate for it here and in these other countries. So my thanks to the IEL and to CALE and TL Cubbage and to the panelists. And with that, I'll say that we're at an end. And again, thank all of you. I appreciate the participants.